My name is Howard Gould, and I'm chair of the real estate section for the Beverly Hills Bar Association. And the real estate section had scheduled, actually prior to the COVID-19 matters, a presentation on asset protection. And our speaker, Jacob Stein, has been kind enough to adapt his presentation to the new issues that everyone is facing in these times. We are happy to welcome Jacob back. He has spoken for us in the past. Jacob specializes in international taxation, business transactions, and asset protection. He's the author of 3 published books and over 30 scholarly articles and technical manuals, including Asset Protection for California Residents, 2nd edition, the first and only book in print on asset protection planning that is specific for California residents. Jacob has given over 600 presentations to a variety of groups, including local bar associations, estate planning councils, and international networking organizations. In his practice, Jacob has represented officers and directors of Fortune 500 companies, Forbes 400 families around the world, celebrities, high net worth individuals, and many others. Jacob also has served as an adjunct professor for 10 years on taxation at Cal State University Northridge in their graduate tax program. Jacob received his law degree from the University of Southern California and his Master of Law in Taxation from my alma mater as well, Georgetown University Law Center. Jacob's practice is with the Aliant Law Group, and Jacob and I are also both members of an international organization called IR Global that is for promoting business across border and throughout the United States. Final comment is everyone will get their certificate of attendance within 24 hours of the presentation. And with that, Jacob, welcome and thank you for giving this presentation.
Thank you, Howard. You know, I've just realized I have never seen you not in a suit. I think I've known you for what, about 20 years?
Yeah, even today.
Even today. Okay, so I am screen sharing. I hope everyone can hear me just fine. I don't know if folks can see me and see the screen share at the same time, or it's one or the other, but hopefully you can at least hear. It's both? Okay, cool. Then I'll try not to make silly faces as I am talking. So today's presentation is somewhat adapted to the current crisis, because asset protection in this day and age is sort of front and center. So I'll give you some examples and explain that to you. Hold on, let's skip all of that. Okay, so let's start the discussion. So in any recession, and we can leave it for another time to argue whether we are already in a recession or we'll be there soon, or we're in a depression or what have you. But in any recession, asset protection becomes an important subject. Why? In a recession, you will have businesses with declining revenues. You will have businesses going out of business, going bankrupt. So what happens in those circumstances very often is that generates lawsuits, right? And people are defaulting on various obligations, loan obligations, lease obligations, with or without personal guarantees behind those obligations. And in those circumstances, whenever you have lawsuits and whenever you have creditor claims, asset protection becomes important. And I will tell you that, with COVID, we started seeing sort of a wave of COVID-related cases beginning about, I would say, 6 weeks ago. It first started with retailers, so owners and operators of restaurants, hospitality properties, retail stores, who either initially were simply just closing on their own because they didn't have any customers, and later were shut down by the government. So they were saying, hey, we have no revenues, but we signed personal guarantees in our lease, or we have a personal guarantee on a bank loan. So they were seeking asset protection. Then a week later, it escalated to, let's say, owners of shopping centers, guys who are in commercial real estate, saying our tenants are not paying us, or they're closing shop, they're out of business. So we are not making any money. We will be defaulting on our loan obligations. And then a week later, we started getting calls from commercial lenders and mortgage lenders saying, hey, we are now going out of covenant because our borrowers are not performing on their loans. And we are worried about the personal guarantees that we have signed. So you can see how just in the span of a few weeks, it went up the entire vertical of the economic chain and then blowing out to all sorts of sectors and industries. I mean, you can sort of use your imagination. Absolutely, everyone has been affected by what is happening. And what I am seeing is that, today, we're not really experiencing any aggressive landlords. We're not experiencing any aggressive lenders. Everyone is trying to be nice. We're all in this together. But as you would imagine, we're all in this together for now, right? We're all in this together while COVID is sort of the big news, and everyone is talking about it, and everyone is impacted by it. In 6 months, in a year, at some point in time, COVID is not going to be what it is today. People are going to start talking about other things, and when that happens, the lawsuits and the creditor claims will start, right? So the smart money is already taking action to protect the assets of the business, or the personal assets. But eventually, I think there's going to be a huge, huge wave of folks engaging in asset protection planning. And we certainly saw that in the last recession, after 2008. I think 2008 to 2012 was probably, I don't know, the golden age of asset protection planning in a sense, right? Because it was this just giant tidal wave of real estate investors, lenders, developers, business owners, and all kinds of people seeking to protect their assets, right? There's some of the things we do not often think about being in California is that in other states, lenders do foreclose. They do go for deficiency judgments, and then they can pursue our clients back to California. So after 2008, we had dozens and dozens of clients who were Californians, but who invested in real estate, in Florida and Utah and, a host of other states. The real estate went upside down. They wanted to walk away from that real estate. And some of them did, some did not, but the ones who walked away did get sued by their lenders seeking a deficiency judgment. And once they got the judgment in whatever state they're located in, they would bring that judgment to California, domesticate it here, and pursue our clients' assets. So the consequences of big recession like what we likely will face is very far-reaching. So what did we learn during the 2008 recession that we can apply today? The first lesson is that probably the biggest thing that our clients can do is they can act now before they default on their obligations. We will talk in a few minutes, very, very briefly, about fraudulent transfers. And it is much more difficult for a creditor to bring a fraudulent transfer argument when the debtor is protecting his assets before there's an event of default. So if the debtor is protecting his assets before there is default, the creditor cannot argue what's called constructive fraud. They can only argue actual intent, and that makes their job more difficult. So we always encourage clients to act as quickly as possible, as early as possible, before there is an actionable claim against them. And then the other big lesson we learned after 2008 is that we never have any idea what actually will happen, meaning that, yes, our client has significant wealth. Our client owes a creditor a significant sum of money. But what will happen, nobody knows. We see creditors who are pursuing our clients very aggressively and very diligently, and we are seeing creditors who just walk away and not pursue clients at all or negotiate for a very, very low settlement. And often there is no way to discern why there is such a different approach. Part of it can be just different corporate culture at different lenders. So for example, I will tell you from experience that Wells Fargo Bank is a very aggressive creditor. Chase and BofA, not very aggressive. Rabobank is very aggressive, and certain small community business banks are very aggressive, but Citibank is not, right? So we do sort of have some experience from the prior recession as to how aggressive and diligent different lenders will be. And that may or may not still be true today, 12 years later, right? And also there are lots of other types of creditors out there. What about the big plaintiffs law firms, right? What about the private equity funds that our clients may have borrowed money from? So we do not know, and we never know in advance, how aggressively a plaintiff or creditor will pursue our clients. So given that we do not know that, how can we possibly know what to do? Like, how well should we be protecting our assets? We'll talk about in a few minutes about a lot of the choices that we get to make when we are seeking to protect assets. But by and large, the old adage of, plan for, hope for the best and plan for the worst certainly applies here, right? Every client wants to do the minimum that is necessary for them to keep their assets. We do not know what that minimum is. So, what do we need to do to make sure the clients get to sleep at night and give them a good, meaningful chance of keeping their assets? Let's talk about what the goals of asset protection planning usually are. And I think there's some misunderstanding often there. And also let's talk about what is possible and what's not possible. And I think these two topics are quite intertwined. So the goal of asset protection planning is really not to protect assets, which I think is a bit misleading, right? Or confusing, because the name of this area of the law is asset protection. The goal is not to protect assets because, with a couple of exceptions, we really cannot make assets unreachable, right? And if anyone promises you that they can make your assets unreachable, they're likely scamming you or lying to you, and it's just usually not in the cards, right? So if we cannot make assets unreachable, what is our goal, right? What are we trying to accomplish? Well, what we're usually trying to accomplish in the majority of cases, or I would say vast majority of cases, is we are trying to make assets more difficult and more expensive to get at, to change the plaintiff's economic analysis of the case, right? And if we can make it difficult enough and expensive enough, what will happen? Well, the statistics that we have compiled over the past 20 years, I don't know, 2,000 to 3,000 clients that we've represented in that time span, is that when a plaintiff, when a creditor or plaintiff is confronted with an asset protection structure, about 30% of the time they just walk away. And again, there's no way today to know who will walk away and who will not, but 30% of the time at a statistical level, they walk away. Of the remaining 70%, I would say 98, 99% of the time, the parties settle, but now they're settling usually on terms that are much more favorable to the debtor. And I would say in 1 to 2% of cases, we see plaintiffs try to penetrate the structures that we have established. And sometimes they're successful in their efforts, and sometimes they're not successful. So you can see that even when we are not making assets impossible to get at, right, we're just making assets more difficult and more expensive to get at, the results are still pretty damn good, right? And also understand that even when we can make assets unreachable, that probably should not be our goal in the long term, because even if we can make our clients' assets unreachable, what will happen in the long term? Well, in California, judgment is enforceable, what, for like 30 years, right? So for 30 years, our client can never have assets in his name and sort of needs to live below the radar, right? That's no way to live. And the judgment on top of that is continuing to accrue 10% interest. So even when we make assets unreachable, that is not a means of not paying a creditor. That is a means of extracting a better settlement from the creditor, because at the end of the day, we want to pay them something and give them some incentive to walk away from us, right? But pay the creditor as little as we can. One of the common, misconceptions, I guess, about asset protection is that folks often associate asset protection with hiding assets. And I want to address that briefly. So hiding assets is not necessarily a bad thing, but there's no substance to hiding assets. Why is there no substance? So once a plaintiff obtains a judgment against our client, they can pull our client into what is known as a debtor's examination. And in the debtor's examination, they can ask our client pretty much any question that they want to that will help them find and collect against our client's assets, right? So imagine if our client employs what I somewhat jokingly refer to as the Home Depot method of asset protection planning. So in the Home Depot method of asset protection planning, our client is expecting a large judgment to be entered against him. So what does he do? He sells all of his assets, converts everything into cash, and then he goes to Home Depot and he buys a shovel, right? He buys a shovel and then he proceeds to dig a hole and bury the cash. And the question is, does that work? Is that an effective means of protecting assets? Well, there are two answers, I would say. One is the technical answer, and the technical answer is that, maybe it's not so protective because of the debtor's exam, right? Because the creditor can pull our client into a debtor's exam. Our client has to answer questions in the debtor exam under penalty of perjury. And what happens if one of the questions is, have you been to Home Depot recently? Right? So now our client is in a position where he will have to perjure himself for Home Depot to work, right? Practically speaking, not a lot of cases wind up in the debtor's exam. It's probably under 5%, I would say. And even in those cases that do wind up with the debtor's exam, not always will these kind of questions or the right kind of questions be asked, right? And of course, not always will debtors be truthful in answering questions in the debtor's exam. And quite honestly, in my experience, debtors are honest in answering questions in the debtor's exam about, 5% of the time. Maybe only if they have a professional license on the line, like doctors and lawyers and accountants and such. So hiding assets, I would say it's not a bad thing to do, because if you are making it more difficult for a plaintiff to find your assets, maybe they will never bring the lawsuit in the first place. Or if there is already a pending lawsuit, maybe they will be a lot more willing to settle if they cannot discover the assets. But it's not something we want to rely upon, right? We as lawyers want to make sure that our clients have a substantive level of protection, that if they are truthfully answering questions in the debtor's exam, the structure that we have established still works and still makes it more difficult and more expensive to protect assets. And then the final point I want to make before we get into the nitty-gritty is that there is no such thing as a perfect structure. Right? There's no such thing as a perfect structure, meaning that any and every structure, and we'll have time today maybe to go through 3 or 4 of the most commonly used structures, but any structure out there is not perfect, right? There may be practical issues of using a structure, like it's too cumbersome, too complicated, it changes my life too much. There may be tax consequences. There are all kinds of downsides, or reasons why something should not work. And very often we will see clients and other lawyers sort of get hung up on why something will not work. What I will invite you to do is to focus not on why something will not work, but on the following question. Is there a better alternative? Right? So if the structure we are discussing is not perfect, but there is nothing else that is better, then by definition, right, we're talking about the best thing that the client can do. So just keep that in proper perspective. There are by the way, sorry to interrupt myself, but I see there are some questions popping up on the Q&A, which is great. It's kind of difficult to speak and then read the Q&A and answer questions and not lose my train of thought. I do that very easily. So please do go ahead and type in your questions on the Q&A as they come up, as you think of stuff. And then when I finish talking, we'll leave like 10 minutes or so to go through the Q&A, and you can ask, again, you can type in questions now, you can ask more questions later. I will answer all of your questions, but just because of the format of this presentation, it will not be live. Okay, so there are probably close to 24 structures that we use on a somewhat frequent basis, and probably a few more, I would say, esoteric structures that are used, once off. So when a particular client comes to us to protect his assets, how do we know which structure we are going to use? So in our office, we go through this analysis that you see on the slide in front of you, looking at these 4 factors. And I'll just run you through them very quickly, but I think these are all kind of very important inquiries to make early on in the asset protection process. First one, who is our debtor? And here I think the most important inquiry will be, how risk averse is the debtor, right? Because 2 clients who are in exactly the same position, who have exactly the same assets, and are facing the exact same creditor may choose to do 2 completely different things to protect their assets, right? Because one is risk averse and the other one is, I don't know, a real estate developer. Then other things we will look at, is the client a natural person? And if they are they married or single? Because there's different planning we can do for a married couple. Is it a legal entity being sued? If it's a legal entity being sued, does the client want to continue to operate the business but not be subject to the liabilities that the business is going to be subject to? So for example, that comes up a lot nowadays in the context of PAGA lawsuits. So we represent lots and lots of business owners facing PAGA lawsuits. And often, these are very significant lawsuits. Some of them are class action lawsuits. And other than these lawsuits, these are very successful, profitable businesses, right? And the individuals who own these businesses do not want to really give them up, right? They want to create some sort of a structure which will allow them to effectively continue to operate the business, but under some sort of a new guise, and preserve the liabilities in the existing business, but move all the operations and all the future revenues and perhaps the assets as well to the quote-unquote new business, right? So if that is our exercise, right, that has a completely different analysis than other things we're talking about today. Because if we are transitioning the business into a new structure, then the most important question will be, will successor liability attach to the new entity, right? And that's somewhat different analysis than other things we are discussing today. We look at the nature of the claim, what kind of a claim is it? Is this the kind of a claim where a prejudgment attachment will be available? So the general rule is that a creditor cannot come after your assets until they have a judgment against you. The exception are claims that arise in a business context where the damages are easily ascertainable. So for example, let's say you are leasing space for your restaurant, and you default on the lease obligations because your restaurant has been closed, or it reopens and it's at half capacity, what have you, and you default on your lease obligations. Well, because your restaurant lease is a contract that's in a business setting, and the damages are very easily ascertainable, right? We know what are the remaining leasehold payments. That is the kind of a claim where prejudgment attachment will be available. And in a prejudgment attachment, the plaintiff is allowed to place a lien on the defendant's assets before they get a judgment, for the, I guess, somewhat obvious purpose of securing the defendant's assets during the pending litigation to make certain that by the time the litigation is concluded, the assets are still there. So again, prejudgment attachment is only available in the context of a business lawsuit where the damages are easily ascertainable. So usually a lease default or a loan default. And certainly with the current economic crisis, we will be seeing a lot of that. And I will tell you from experience that when we do have a client where we think that prejudgment attachment is possible, and they come to us and say, a lawsuit was just filed against us, or we think a lawsuit is just about to be filed against us, what do we do? The planning is different than traditional asset protection planning, because now we need to really move very, very fast to get assets out of our client's name, to get assets out of the state of California, just to make sure for now that the prejudgment attachment lien will not attach to anything. And then once we concluded those initial steps, then we can look at more substantive, more long-term structures. Obviously, the timing is super important. When are we engaging in asset protection planning, right? If we are protecting someone's assets today, when everything, let's say, is still nice and fine and calm in their life, you can set up fairly simple, fairly inexpensive structures, and they will work really well. They will have great efficacy. Whereas if you're planning after the fact, right, after there's been a loan default, after our client ran over a troop of Girl Scouts, after there's been an act of malpractice, or even after a lawsuit has been filed, now we're acting after the fact. It is easier for a plaintiff to argue that the asset protection that was implemented is a fraudulent transfer. So the structures we are using have to be a lot more robust and a lot more aggressive to have a chance of working. We look at the identity of the creditor, so how aggressive the creditor will be, how intelligent are they when it comes to collecting on a judgment. And usually, like in a live presentation, when I ask the question of who do you think is the most aggressive creditor out there, the answer, I'll give you a second to think about it and take a sip of water. The answer that most people come up with is the Internal Revenue Service. They are the most aggressive creditor. And in my experience, I will rank them, I should say. I will rank them maybe number 5. So certainly other federal agencies are in the level of aggressiveness and let's say just general awfulness are well ahead of the IRS. So the FDA, FTC, SEC, much nastier to deal with than the IRS. The state collection agencies often can be much more aggressive and less bound by the rule of law than the IRS. So they will all be ahead. Certain banks will be more aggressive than the IRS. And certainly the most aggressive creditor and the most difficult one to go up against will be either a former spouse or a former business partner. Because usually in these types of lawsuits, there's an emotional element or psychological element to the lawsuit where the other side may not really care how much they will collect. They may not care so much about the economics of the lawsuit, right? For them, it's all about getting that defendant and sticking it to them. So in cases like that, making it more difficult and more expensive for the plaintiff to go after our client's assets is not enough, right? We really have to make it pretty much impossible or it's not going to work, right? It's not worth the effort. And then the final factor we consider in determining what type of a structure we will set up are the nature of the assets we are protecting. So depending on the types, categories of assets that the client has, different structures will be considered, right? So if our client has a personal residence, the structures may be different than when we are protecting income-producing real estate or liquid assets in the bank or intellectual property or what have you. So just for different categories of assets, different structures will come into play. So we will look at the sort of the totality of these factors to be able to suggest to the client, here are the options that we think will work best for you. Here is how well we think each option can protect your assets, and let them sort of decide what makes the most sense to them to pursue. Let's talk just very briefly about fraudulent transfers. So, I sometimes teach hour to hour talks on this topic alone. This actually used to be called fraudulent transfers. I still refer to it this way because this is how most people know this body of law. Nowadays, it's called the Avoidable Transfers Act, the Uniform Avoidable Transfers Act. But the logic behind both acts is pretty much the same, right? So a creditor can set aside a transfer that involves actual intent to hinder, delay, defraud a creditor, or what's called a constructively fraudulent transfer. So just very briefly about each one of these. So the transfer with the actual intent to hinder, delay, defraud, how do we know what is someone's actual intent, right? Because your intent is inside your head, and no one else really knows what goes on inside your head. How do we know? How does the plaintiff prove in a court of law what the debtor's intent was behind the transfer? So intent is proven through circumstantial evidence, what is known as badges of fraud. So we look at the circumstances surrounding the transfer, like when did the transfer take place? Was it before the default or after the default? Before an accident or after an accident? Who was the transfer to? Was this a transfer to an entity that the debtor controls or to a family member or some sort of an insider? Was this a transfer for less than fair market value, which is probably the most important consideration in this analysis? Was the debtor insolvent or was left insolvent at the time of the transfer? Probably the second most important consideration. And there are a few more badges of fraud. So these badges of fraud, again, are used to establish intent. And then there is a constructively fraudulent transfer, and that's any transfer that is for less than fair market value when the debtor is insolvent or the debtor becomes insolvent as a result of the transfer. So with a constructively fraudulent transfer, we don't really care what the intention was. We're looking only at these two factors. It's a fairly mathematical, I would say, analysis, right? Was this a transfer for fair market value? Was the debtor left insolvent? These are also the two most important badges of fraud. So whenever we are engaging in asset protection planning, where we think that there's a good chance that the plaintiff will challenge what we have done as a fraudulent transfer, we do want to make sure that we're not leaving the client insolvent if that's possible, and that at least the transfer is for fair market value. That is much more in our control, right? We have a lot less control over whether our client is solvent or insolvent. That's just sort of the mathematics of the balance sheet. But whether a transfer is for fair market value or less than, that is within our control. Let me now sort of go to what I think is the most important point to make in today's presentation. And today's presentation, being on the shorter side, I'm kind of skimming through some of these topics. And I'll give you a recent client. Well, actually, I'll give you an example from the prior recession, from the 2008, that I think is very much on point today. And we'll probably see it repeated many times in the COVID recession. So I think this was in 2011 or 2012. I had a client who was a lady in her mid-70s, and her son, before 2008, I think it was like in 2007 or maybe even early 2008, her son decided to become a real estate developer. He's never done any work of any kind in his life until that point. He had no assets of his own. But he managed to borrow $5 million from the bank on his mama's personal guarantee. So I think he was a real estate developer for about 3-4 years, and then everything crashed. And he walked away, and the lender never went after him because they knew that he had no assets. So mama was left holding a $5 million personal guarantee, which I think with interest and penalties and legal fees and what have you, was probably closer to $6 million. And in the meantime, her net worth declined, I think, from about $8 million to about $5 million. So she is looking at a complete wipeout of all of her net worth. She went to quite a few law firms in both in LA and in New York. And every law firm she went to basically said, first of all, we don't think there's anything you can do. There's already been a default on the loan, and you signed a fairly straightforward personal guarantee. And second, we don't want to get involved in something like this. So let's for now look at her situation purely from her point of view. Let's stop being lawyers for a second and just put ourselves in her shoes. And if you are in her shoes, first of all, you're probably pretty scared, right? Because you've never been through something like this before. And there is a fairly high chance that you will lose everything that you have, right? So what choices does she have? Well, her choice is really binary if you think about it, right? So A, she can choose to do what all these law firms recommended, which is do nothing. Or B, she can choose to do something to protect her assets. If she chooses to do nothing to protect her assets, what are the odds that she will lose everything that she has? I mean, I would say the odds of her losing everything that she has are about 100%, right? Give or take 0. Whereas if she tries to do something to protect her assets, maybe the plaintiff will challenge that as a fraudulent transfer, maybe not. And if they challenge that as a fraudulent transfer, maybe they will prevail, but maybe they will not prevail. And even if they prevail, what happens? Well, they get to unwind the transfer. They get to reach the transferred assets, which may or may not be possible, right? Depending on what has been done with those assets. So again, purely from her point of view, if you put yourself in her position, right, you're going to lose everything that you have, everything that you spend your entire life working your ass off. What are you prepared to do to keep what you have? Fortunately for her, she chose to do something to protect her assets. And what ended up happening is that the bank, they took a look at the asset protection structure that was set up, at what happened to her assets, and they decided not to pursue her. And some years went by, and they never renewed the judgment, and now she is entirely in the clear. Obviously, no one can predict or guarantee that sort of a result. But what I can tell you is that, what I can guarantee is that if she did not do something to protect her assets, this result would be obviously impossible. As the great Wayne Gretzky used to say, 100% of the shots you do not take do not go in, right? And very often that is our philosophy with asset protection planning. For our clients at the very least, there is often not a downside to trying, because they're going to lose everything anyway. So why not try to protect what you have? And perhaps maybe you will not get to keep everything that you have, but maybe a good settlement can be negotiated and you get to keep a good chunk of what you have. I think the obvious question at this point is, like, what about the lawyers? What about all of us advising a client in this context to protect their assets? What if that is a fraudulent transfer? Well, so first of all, understand, please, that fraudulent transfers do not exist sort of ab initio. Someone has to bring a lawsuit for a fraudulent transfer, and then the judge has to rule that, in fact, the transfer that was engaged in was what is now called a avoidable transfer. But without that lawsuit, no transfer is a fraudulent transfer, right? It's all purely theoretical. And given the statistics that we have, how infrequently fraudulent transfer lawsuits are brought by creditors, I think for the vast majority of clients and practitioners, it's sort of like an academic exercise trying to figure out, will something be a fraudulent transfer and what is our exposure? There may be some liability exposure for the practitioner, so certainly you do need to be very, very careful as far as the cases you take on, right? And what your ethical and other obligations may be. You want to make certain that you do not get sued by the creditor for aiding and abetting in a fraudulent transfer, because that is not a lawsuit that is covered by malpractice insurance, right? Because it's not an act of malpractice. So you do need to tread very, very carefully, and you do need to have the stomach for it. So we only have, we have very little time. Let's talk very briefly about a couple of structures that are used very often in asset protection. And we're just going to clear up briefly some misconceptions. So legal entities are very frequently used to protect assets. And primarily, we're talking about limited liability companies and maybe to a lesser extent, limited partnerships. And I would say outside of California, we're talking only about limited liability companies. And in California, we're talking about LLCs and perhaps limited partnerships as well. So in California, we do sometimes set up limited partnerships because of the gross receipts tax that the LLCs are subject to. I think Texas is the only other jurisdiction that has a tax like that on limited liability companies. But everywhere else, people use LLCs, and it's rare to see limited partnerships. So why do we use LLCs and LPs? With an LLC or a limited partnership, even though your interest in the legal entity is personal property, it is not attachable by a creditor, meaning a creditor cannot take it from you. Contrast that with shares of stock in a corporation. If you have shares of stock in a corporation, whether it's a public corporation or a private company, the shares of stock are attachable. It's personal property, and like any other personal property you own, a creditor can take it from you. right? So most of the time we will see clients hold their valuable assets through an LLC or a limited partnership. And it can be any kind of an asset imaginable. There are really no limitations to speak of. What are some of the nuances of, let's say, using LLCs? We'll just focus on LLCs because that's what most of us use most of the time. So with LLCs, the only word of caution is perhaps, if possible, use multi-member LLCs instead of single-member LLCs. Judges are, a lot more likely to allow the piercing of the corporate veil in a single owner entity. And that's probably true of whether it's a single shareholder corporation or a single member LLC. A multi-owner entity is just perceived, has the optics of being really separate and apart from the owners of the entity. So it's even more difficult for the plaintiff to pierce the corporate veil of an LLC. And by the way, I don't know if this is something you've ever thought about, it is more difficult to pierce the corporate veil of an LLC than the corporate veil of a corporation, right? Because with corporations, we have the formality requirements that apply, whereas LLCs are not subject to any formality requirements. So we're taking sort of a big piercing argument away from the plaintiff. So we do very frequently see clients hold valuable assets through LLCs and similarly through limited partnerships, because now your interest in this entity is not attachable, whereas the asset that you used to own yesterday that you transferred to this entity would have been attachable. So, and again, I apologize for skipping some of the slides. I teach these presentations sometimes over anywhere from 3 hours to 8 hours, depending on the setting. So in 1 hour, obviously, we cannot cover every single topic imaginable. I do want to spend a little bit of time on trust, because trusts are certainly, in my opinion, the heart and soul of asset protection planning. So first, let's consider the following. The goal of every single asset protection structure is really the same, right? What is the goal? Well, before we can understand the goal, we need to understand what is it that the creditor is capable of doing, right? So once a creditor obtains a judgment against our client, with that judgment, the plaintiff can go after pretty much any and every asset that our client owns, unless the asset happens to be exempt under state law. Right, so in California, a small amount of equity in your home is exempt from creditor claims, the so-called homestead exemption. Certain types of retirement plans are exempt or may be exempt, and a few other assets of fairly nominal value are exempt from creditor claims. But pretty much anything and everything else that is not exempt, a creditor can take from you. The flip side of this coin is that if there is an asset that you do not own, a creditor cannot take it from you, right? Because it's not yours. So every single asset protection structure aims to do the exact same thing, which is to take an asset that our client owns and make it into an asset that our client does not own, right? So every single asset protection structure does exactly that. Take an asset that our client owns, make it into an asset that the client does not own. Well, if you think about it, that's not difficult to do, right? Take all of your assets, give them to the Salvation Army, and you will no longer own them, like ever again. Obviously, there's a little caveat, right, in making the assets not yours. We want to make the assets not yours in such a way so that you can retain control over these assets that you have, that you can retain the ability to transfer the assets back into your name when you choose to do so, right? And perhaps you want to engage in all of these transfers of assets without any tax consequences. So a limited liability company that we just discussed is a great example of accomplishing that, right? If we, for example, have a client who owns an apartment building that's in his name and therefore is reachable by a creditor, and he transfers the ownership of that apartment building into an LLC, and he now owns a membership interest in a limited liability company, yeah, he no longer owns the apartment building, but he has retained the ability to control that apartment building because he's probably still the manager of the LLC. He has retained the ability to transfer the ownership of the apartment building back into his name. and there are usually no tax consequences on these transfers, right? With a trust, it's sort of the same exercise. It's the same objective. We want to transfer an asset into a trust, make it not ours, retain control, retain the ability to transfer the assets back into our name, and accomplish all of that without any tax consequences. So how can a trust allow us to do that? Well, first of all, every asset protection trust is always irrevocable. Irrevocable. If the trust is revocable, like your common living trust, it's great for avoiding probate and dealing with incapacity, but it doesn't do anything from an asset protection standpoint, right? So we have to have an irrevocable trust. And the big problem that people have with an irrevocable trust is that, we think that with an irrevocable trust, you lose control. The structure is sort of cast in stone, right? We cannot unwind it. We cannot get our assets back. We don't get to change our mind tomorrow. And just, very briefly, that used to be true, right? That used to be true for how long? For like 400 years. That was true about irrevocable trust, which is why we all think that way about irrevocable trust. But it's no longer true. Now, with an irrevocable trust, we can structure the trust in such a way that even though it's still irrevocable and our client does not, in a technical sense, have any control over the trust or its assets, in a practical sense, he does retain that control. He does retain the ability to get his assets back, to effect changes in the trust agreement and the trust relationship, and we can engage in all of these transfers of assets back and forth without any tax consequences. So what is the distinction between using an LLC and using a trust? Like, how do we know when to use which one? I'm just kind of jumping ahead to that given the limited time we have left. So the trust, I believe, gives you a bit more protection than the LLC, but it's not always easy to use. So in California, and I believe in pretty much every other state, you usually would want to have a trust that has a third-party beneficiary, meaning someone other than the settlor, someone other than the person who funded the trust should be the beneficiary. And even though there are now about 15 states that allow self-settled trusts as asset protection shields, I do not believe in using self-settled trusts for reasons that are, well, we don't have time to get into right now. So we want to have a third-party beneficiary in the trust. What that means is that if we are transferring a cash-flowing asset into some sort of an asset protection structure, we probably do not want to transfer a cash-flowing asset into an irrevocable trust, right? So our client owns an apartment building that is producing positive cash flow, and we transfer the ownership of that apartment building into an irrevocable trust. Well, the cash flow now can only go to the beneficiaries of the trust, or it can get trapped within the trust itself, but it cannot be distributed to our client because he is not the beneficiary. So usually with cash flowing assets, we use limited liability companies. Non-cash flowing assets like a personal residence will use an irrevocable trust. And I do think that an irrevocable trust has a big advantage, big benefit over the LLC, and it's the following. And I wish I had a lot more time to share client anecdotes with you guys because I have like hours and hours worth of client anecdotes that are fairly amusing or educational. But so here's one. We had an elderly client who plowed into a group of pedestrians. No one was, seriously injured, but there was a fairly large group of pedestrians that he plowed into. So the cumulative lawsuit was for about $1.5 million, and he only had, I think, the minimum insurance coverage on the car, like 35 or 50,000, something like that. And this lawsuit was dragging on for over a year. After a year, we were retained, and the client said, I have a residence. It's worth about $6 million. I would like to protect it from this lawsuit that's been pending for a year. So we transferred the ownership of that residence into an irrevocable trust. And literally within a month or so, the defense counsel submitted a financial declaration to the plaintiff counsel saying, listen, all that our client has is a Social Security check. He does not have any assets. Here is a financial declaration that he signed under a penalty of perjury. They settled the case that same day for like something roughly around $50,000. Now, would that have worked if the creditor was not a plaintiff's lawyer, but let's say a bank, right? Or a plaintiff's lawyer who has a lot more experience with collection actions, right? And inquiries like that. Probably not, because all they needed to do was ask, have there been any recent transfers of assets? And then the structure would not have worked. But this plaintiff did not ask. And because the asset was transferred to an irrevocable trust, it completely came off the financial statement, right? Completely came off the client's PFS. If we transferred that personal residence into an LLC, there would still be an asset on the financial statement with exactly the same value, which maybe have led the plaintiff to asking more questions and maybe settling them for more money. The irrevocable trust, and because the assets do entirely come off the PFS, does have a downside, right? Because for some of our clients who want to continue to qualify for loans, who want to continue to build projects and what have you, they now have a smaller net worth, right? So maybe for clients like that, an irrevocable trust is not the way to go, or we are very judicious as to what assets are placed into this irrevocable trust. Howard, I'll take 5 more minutes if you don't mind.
Okay.
And I'll talk about offshore structures, and then we can wrap up the hour there, and I'll open it up for Q&A. So, I mean, this slide is titled Foreign Trust, but really it's not just about foreign trust per se, it's about offshore structures, foreign structures, which run much deeper than just trusts. So we just talked about domestic irrevocable trust. What is so special or different about setting up a trust overseas? Well, there are 2 aspects to it. One is there are jurisdictions that have intentionally changed their trust laws and other statutes that they have to offer exceptional protection to debtors who are holding assets inside of a trust in these jurisdictions, right? So these jurisdictions, for example, some of them have pretty much eliminated the creditor's ability to argue a fraudulent transfer in any meaningful way. Some of these jurisdictions have a very short statute of limitations. Some of these jurisdictions do not recognize judgments from a foreign country if it somehow affects a local trust, and there are many, many more. So that's on the technical side. On the practical side, which I think is so much more important and something that people do not focus on enough, is that once you have your assets owned by an overseas structure and the assets themselves are cited overseas, a US-based judge no longer has any control, he no longer has any jurisdiction over anything, right? He is not controlling the person who is holding legal title to the assets because that person is overseas, and he has no jurisdiction over the asset itself because the asset has moved overseas. I will tell you that over the past 20 years, I don't know how many offshore structures we have set up, 400, 500, 600, I have no idea. We have yet to see any creditor pursue an offshore structure. Now, I know some of my colleagues where they have seen it, colleagues from around the country, but it happens very rarely. And to us, it has never happened. I think it's just dumb luck. I don't think we're doing anything special. But it just sort of shows you that the odds of a creditor going after an offshore structure is fairly small. And the vast majority of cases that we handle are usually very, very high stakes cases with very large dollar amounts, with very large aggressive creditors. Federal agencies, big class action law firms, private equity funds, and the like, and former spouses. And we have not seen any creditors pursuing assets overseas. So I don't believe that an offshore structure is some sort of a panacea for what ails you. But for the right client who are facing some sort of, a bet the farm type case, which may result in a huge judgment, an offshore structure may be warranted. So I think with that, I mean, there's so much more I can tell you guys. Let me just make sure I haven't forgotten anything super important. Oh, just very briefly, sorry, 1 more minute, on retirement plans, because this is specific to California. There is this misconception out there that in California, IRAs are exempt from creditor claims. That may be true for some folks, but certainly I think for everyone who is listening in to this presentation, it is likely not true, and someone who can afford to be your client their IRAs are likely also not exempt. So it's just something that requires a closer look. It is a subjective test that California courts use to determine whether IRAs are exempt from creditor claims. So do not assume that IRAs are exempt. It does require further analysis. Okay, with that, let's open it up for questions. And Howard, if you'd like to, I can just kind of go through the Q&A.
There's one, the first one, Jacob, was how does somebody get future credit after they've set up this asset protection structure?
Well, so yes, I mean, and this is just something that I addressed. I think the question was asked earlier. You're correct. I mean, it's a very legitimate question because you either own an asset or you do not, right? And if you own an asset, your financial statement looks better and you can get credit. And if you do not own an asset, it is better protected from creditors. So it is very, very difficult to have both because those are often mutually exclusive. There are ways to sort of cheat the system a little bit, right? And kind of try to do both. But often we do have to make a choice. And usually the choice is, you know, we have an acute asset protection need, like we need to protect assets today, because today we have a creditor aggressively pursuing us. And then tomorrow we'll return the assets back into our client's name and he can get his loan.
Jacob, I have heard some asset protections lawyer talk about using, I think it was Delaware trusts or Nevada LLCs because of special protections in those states. So does it make a difference as to whether you're going to set these up in California or somewhere else in the US?
So, I mean, listen, it certainly makes a great deal of difference from a marketing standpoint, Howard, and perhaps the amount of fees that these lawyers charge clients. Delaware, Nevada certainly does have better asset protection laws that are much more debtor friendly than, let's say, California does. I mean, California, it's probably the most creditor friendly state in the union. But really the relevant question will be, will a California judge be bound by the choice of law we've made, right? Because the choice of law we make, like for example, where the LLC is organized, or the choice of law we make in the trust agreement, that is only binding internally. It is never binding on third-party creditors, right? So the creditor can still go through a choice of law analysis and argue that California law should apply to the Delaware trust or Delaware LLC. So I don't think that, usually I don't think there's much extra protection with those out-of-state trusts or LLCs. Okay, you want me to read more questions, Howard?
If you have others there, I only see one.
How to do prejudgment attachment. I'm not a creditor's rights attorney, so I have no idea how one goes about a prejudgment attachment. How do you maintain control over the irrevocable trust? So usually that's done by appointing a trust protector, right? So this is a position we create within the trust relationship in addition to the trustee, and the protector is given powers to revoke the trust, terminate the trust, amend the trust, change the trustee, change the beneficiaries, change the governing law, switch between grantor, non-grantor status, veto distributions, force distributions, things like that. And our client, the settlor, retains the ability to remove and replace the protector. So that's how control is retained. Who do you name as the beneficiary of the irrevocable trust? You know, I encourage all of our clients to name my children as the beneficiaries of their irrevocable trust, but they rarely do that. Probably never done that. You know, it has to be just someone other than the settlor of the trust. Really doesn't matter who it is, right? So long as it's technically a third person, someone other than the settlor, and in California, someone other than the spouse of the settlor, right? Because usually if we're working with community property rules, both spouses will be deemed settlors of the trust, even if only one is transferring assets to the trust.
So Jacob, which foreign jurisdictions are you using these days?
So for asset protection, you know, so it depends on what for, right? So for setting up, let's say, a trust, we primarily use St. Vincent and the Grenadines. For many years, we used the Cook Islands, but I think Cook Islands has become fairly notorious as an asset protection jurisdiction. certainly after the Paradise Papers, a bit too notorious. St. Vincent has identical laws to the Cook Islands because they photocopied the trust laws of the Cook Islands. And it's, sort of flies under the radar, which I like. We use NIDAS for offshore LLCs. We'll use Panama or Hungary for offshore private foundations, usually Hungary because they have much greater privacy rules. Panama now enacted a new law where beneficial ownership of corporations, foundations, and the like have to be disclosed to the Panamanian government. So I don't think people will be using Panama much more for offshore type of planning. And then banking itself usually will be in Europe.
Thank you very much, Jacob, for doing this presentation for the Bar Association. We very much appreciate it, and look forward to, when the time is right, to having you come back and do it again. And thank you to everyone who's attended. I hope that we met your expectations. Thank you very much.
Thank you, Howard.